For many years, countless Americans have constructed their complete retirement strategies around a basic belief that the regulations controlling their pensions, taxes, and savings wouldn't abruptly shift after they had already invested years, sometimes many years, organizing their future. But a subtle determination from the Supreme Court has just disrupted that belief in a manner almost nobody anticipated. In a united ruling, every single justice on the court concurred on something that could transform retirement safeguards across the complete country. The determination didn't just resolve a legal discussion, it fundamentally altered how states are permitted to handle the financial commitments people depend on when organizing their retirement. And the unexpected part is that most Americans haven't even learned about it yet. There were no enormous headlines controlling every news outlet, no intense political conflicts playing out for weeks continuously. Yet, the consequences of this ruling could extend into pensions, retirement taxes, and long-range saving strategies for countless people. Consider this for a moment. Imagine you've invested 20 or 30 years carefully organizing your retirement. You determined when you could retire. You selected where you would reside. Maybe you even relocated to a different state because of its retirement tax regulations. All of those choices were founded on the regulations that existed at the time. But what occurs if a state government abruptly determines to modify those regulations after the fact? Could they rewrite the arrangement after you've already constructed your life around it? That question has been lingering over retirement organizing for years, and until now, the response wasn't always evident. States have frequently contended they have extensive authority to modify policies whenever budgets become tight. Retirees and workers, conversely, have contended that modifying those regulations after many years of organizing feels like the foundation being removed from under them. Now, in an uncommon and significant moment of complete agreement, the Supreme Court has intervened and delivered a conclusive response, and what the court determined could establish a nationwide legal protection around retirement expectations that countless Americans depend on. But the actual story isn't just that the court ruled, it's why they ruled the manner they did, how this determination alters the balance of authority between individuals and state governments, and who stands to gain the most from these new safeguards. Because once you comprehend what the justices actually stated, you start to understand this ruling could silently transform the regulations of retirement organizing in ways that are only beginning to develop. Hello, I'm Sofia, and today we're going to analyze this Supreme Court determination step by step so you can clearly comprehend what altered, why it matters, and what it could signify for your financial future. Many legal rulings get reported in a manner that makes them sound complex or distant from everyday life, but this one is different. The core concept behind the determination is actually surprisingly straightforward, and once you see how it operates, it becomes evident why legal professionals are already calling it one of the most important retirement-related rulings in years. In the next few minutes, we're going to examine precisely what the court determined, how it impacts retirement regulations across all 50 states, and why countless workers and retirees could now have stronger safeguards than they did before. We'll also examine who gains the most from this ruling, including public workers, retirees who relocate to different states for tax purposes, and people currently constructing their savings through retirement accounts. And later on, I'll show you a few practical steps professionals recommend taking right now so you can safeguard your own retirement organizing in light of this new legal environment. Because while the ruling itself is significant, comprehending how it operates and how states might respond to it could make a real difference in how protected your retirement strategies are moving forward. So to comprehend why this determination is such a major development, we first need to start with what actually occurred at the Supreme Court and why the fact that the ruling was united makes it far more significant than most people understand. To comprehend why this ruling carries so much influence, you first have to examine something that almost never occurs at the Supreme Court anymore. Every single justice concurred. This wasn't a narrow 5-4 division where half the court strongly disagreed with the other half. It was a full 9-0 determination. Justices appointed by presidents from completely different political parties all reached the same conclusion. In the legal world, that type of agreement sends a significant signal. It tells lower courts, lawmakers, and government organizations that the principle behind the determination isn't disputed inside the court. It's established regulation, and when the Supreme Court speaks with that type of unified voice, it often establishes a precedent that influences how policies are composed for many years. The reason this particular ruling matters so much is because it centers around a concept the court described as fundamental reliance interests. At first glance, that phrase sounds like complex legal language you'd expect to hear in a courtroom discussion, but the meaning behind it is actually straightforward. The court acknowledged that when people make major long-range choices founded on regulations that governments have already established, those choices establish legitimate expectations that deserve safeguarding. Consider the types of selections people make when organizing retirement. Someone might determine how much to save each year founded on how retirement income is taxed in their state. Another person might accept a public sector position with a specific pension formula in mind, knowing that the benefits committed after many years of service will form the foundation of their retirement income. Others might even relocate across the country, selling homes and moving closer to family or to states with more beneficial retirement tax policies. None of those choices occur overnight. They are constructed slowly over years, sometimes over complete careers, and every one of them depends on the assumption that the regulations guiding those choices will remain reasonably stable. What the Supreme Court essentially stated in this ruling is that those expectations are not just personal hopes or financial estimates. They can carry constitutional importance. When a state establishes regulations that people reasonably depend on while organizing their financial futures, the government cannot simply reverse direction later in a manner that causes important damage to those who depended on those regulations. In other words, the court indicated that long-range financial organizing founded on existing regulation deserves meaningful safeguarding. This is where the determination establishes one of the biggest changes in legal authority that retirement policy has witnessed in years. Before this ruling, states frequently had wide flexibility to adjust retirement-related policies whenever budget pressures developed. Legislatures could modify how pension formulas operated, alter retirement benefit calculations, or change the manner retirement income was taxed. And while individuals sometimes challenged those modifications in court, they usually faced a steep, difficult struggle. The responsibility of evidence was typically on the retiree or worker to prove that the government had acted inappropriately. That meant hiring lawyers, navigating complex legal systems, and frequently attempting to establish that the modification violated constitutional safeguards, a difficult and costly process. For many people, the practical reality was that once a state determined to alter the regulations, there was very little an individual could realistically accomplish about it. The new ruling reverses that dynamic in a very significant manner. Instead of forcing individuals to establish that a government modification is unjust, the court structure places much more responsibility on the state itself. When a policy modification threatens to disrupt long-standing reliance interests, the government must now justify that choice under a much stricter constitutional standard. In straightforward terms, the presumption starts to lean towards safeguarding the people who depended on the original regulations. If a state wants to change retirement regulations in ways that impact people who organize their financial future around them, the state now has to explain why that modification is necessary and why it outweighs the damage caused to those individuals. That change may sound subtle at first, but legally it represents a significant rebalancing of authority. Instead of retirees and workers constantly defending themselves against policy modifications, governments may now find themselves defending those modifications in court. And that single reversal, who carries the responsibility of evidence, is one of the main reasons legal analysts believe this determination could extend across retirement systems, tax policies, and pension programs nationwide. Once you comprehend how the legal balance has changed, the next obvious question is who actually gains the most from this new safeguarding. Because while the ruling technically applies nationwide, its real influence will be felt most strongly by certain groups of people whose retirement organizing depends heavily on long-range government policies. Professionals generally identify four groups that stand to obtain the most immediate safeguarding under this new legal structure. The first group is state and local government workers. We're discussing teachers, firefighters, police officers, public health workers, city workers, and countless others who invest their careers working in public service. Many of these workers accept lower salaries during their careers with the comprehension that a defined pension will support them in retirement. Those pensions are typically constructed on formulas that determine benefits founded on years of service and salary history. In the past, when states faced serious budget pressures, some lawmakers attempted to adjust those formulas by reducing cost of living adjustments, increasing retirement ages, or altering how benefits were determined. What this ruling indicates is that if someone invested years working under a specific pension structure and contributing to it with the expectation that those regulations would remain consistent, the state may now face important constitutional obstacles before modifying those terms in ways that damage existing workers or retirees. The second group that could gain significantly includes retirees who relocate to another state founded on retirement tax policies. Every year, thousands of Americans move after they retire. Sometimes it's to be closer to family, sometimes it's for weather or lifestyle reasons, but very frequently, it's also because certain states promote beneficial tax treatment for retirement income. Some states, for example, do not tax pension income at all. Others provide exemptions for certain retirement benefits or Social Security income. When people make a choice as major as selling their home and moving across state lines, those tax policies frequently play a major role in the determination. Under the reasoning outlined in this ruling, if someone relocates specifically because a state committed certain retirement tax advantages and the state later attempted to eliminate those advantages in a manner that significantly damaged those retirees, the individuals could now contend that their dependence on the earlier regulation deserves constitutional safeguarding. The third group includes countless workers currently saving through retirement accounts like 401ks, 403bs, and other employer-sponsored strategies. While these accounts are primarily controlled by federal regulation, state policies still impact how retirement income is handled, particularly when it comes to taxation or distribution regulations. If a state were to implement policies that significantly altered how that retirement income is handled after people had invested many years contributing under a specific set of expectations, this new legal structure could become relevant. And the fourth group, which frequently goes unnoticed in discussions about retirement policy, includes Social Security recipients in states that tax those benefits. Only a handful of states currently tax Social Security income, but for retirees residing there, even small policy adjustments can significantly impact monthly budgets. If a state were to introduce new taxes or expand existing ones in ways that materially impact retirees who organize their finances around previous regulations, the reasoning behind this ruling could become a significant tool for challenging those modifications. To see how this safeguarding might operate in the real world, it helps to examine a straightforward example. Imagine someone who invested 30 years working, saving carefully, and organizing for retirement. Over time, they research different states and discover that certain places offer important tax advantages for retirees. Perhaps a state promotes that pension income is not taxed, or that retirement benefits receive special exemptions. After carefully reviewing those policies, the person determines to relocate there after retiring. They sell their house, move, establish residency, and construct a retirement budget founded on the comprehension that their pension or retirement income will not be taxed by the state. That choice isn't just a casual selection, it's a major life relocation involving housing, healthcare providers, community connections, and long-range financial organizing. Now, imagine that several years later, the state legislature faces a budget shortfall and determines to introduce a new tax on retirement income. Under older legal interpretations, retirees might have had limited ability to challenge that modification. The state could contend that tax policy is always subject to revision and that lawmakers must retain flexibility to manage state finances. But under the structure described in the Supreme Court's ruling, the situation may appear very different. Those retirees could contend that they made a major financial and lifestyle choice in direct dependence on the state's earlier regulation. Their relocation, housing selections, and long-range budgeting were constructed around that commitment. If the state abruptly modifies the regulations in a manner that significantly damages them financially, courts may now examine whether that modification violates those reliance interests the Supreme Court described. In other words, the government may need to prove that its choice is justified despite the damage it causes to people who organized their lives around the previous regulations. That possibility alone is why this ruling is already attracting so much attention among retirement policy professionals, pension analysts, and legal scholars, because it suggests that retirement organizing choices, once considered largely personal financial calculations, may now carry a level of constitutional safeguarding that didn't clearly exist before. Of course, the Supreme Court didn't just introduce an extensive principle and leave it at that. The justices also outlined how courts should assess future cases where retirement regulations are altered after people have already depended on them. In other words, they established a structure judges can use to determine whether a state has crossed the boundary. Legal analysts frequently describe this structure as a type of reliance impact evaluation, and while the name may sound technical, the organization of the test is actually quite straightforward. It essentially asks three essential questions that must be examined whenever a government policy modification threatens people who organize their financial future around earlier regulations. The first question is whether individuals actually depended on the existing regulation when making long-range choices. In most retirement situations, that response is fairly obvious. Workers determine how much to contribute to their retirement accounts, when they can afford to retire, and where they will reside, founded heavily on the legal and financial conditions in place at the time. Someone who invests 20 or 30 years paying into a pension system under a specific formula is clearly depending on that structure when organizing their future income. A retiree who relocates to a different state because it offers beneficial tax treatment for pensions is also depending on those policies. If that dependence can be proven, it establishes the first major piece of the legal discussion. The second question focuses on damage. Courts will examine whether the government's new policy causes material financial harm to the people who depended on the previous regulation. Minor administrative adjustments might not meet that threshold, but if a new policy reduces pension benefits, imposes unexpected taxes on retirement income, or changes financial regulations in ways that significantly reduce someone's expected retirement income, the damage becomes much easier to prove. And when both dependence and material damage are present, the legal responsibility begins to change in a meaningful manner. That's where the third and most significant question comes in. The state must show that it has a compelling reason strong enough to justify making the modification despite the harm caused to those individuals. This is where many potential policy modifications could face serious examination. Governments frequently adjust financial policies to address budget shortfalls or political priorities, but under the reasoning of this ruling, simply stating that a state needs more revenue may not automatically justify rewriting regulations that people depended on for many years. Courts could require a much stronger explanation before permitting those types of modifications to stand, and that combination of factors is what establishes the new dynamic many legal observers are focusing on. Instead of retirees and workers always being forced to establish the government acted inappropriately, the legal structure now asks the government to explain why it is justified in overriding the dependence people placed on earlier regulations. It's a subtle but significant shift that alters the starting point of the legal conversation. Comprehending the legal structure is significant, but the real question for most people is what they should actually accomplish with this information. Because while a Supreme Court ruling can transform the legal environment, it only becomes truly useful if individuals know how to safeguard themselves within that new structure. Consider this moment less as a piece of news and more as a resource, something that can help strengthen the financial organizing you've already been constructing for years. Professionals who study retirement regulation frequently suggest 3 practical steps that people can take to ensure their organizing is supported by evident evidence of dependence. The first step is documentation. This may sound straightforward, but it's incredibly significant. If reliance interests become significant in future legal disputes, the ability to show precisely what regulations existed when you made your financial choices could matter a great deal. That means maintaining records of the policies that influenced your retirement organizing. For example, you can visit your state's Department of Revenue website and locate the pages explaining how retirement income, pensions, or Social Security benefits are taxed. Saving a copy of those pages, whether as a screenshot, a printed document, or a digital file, establishes a record of the regulation as it existed when you reviewed it. The same concept applies to pension enrollment materials, retirement account documentation, benefit statements, or official notices explaining retirement regulations. Every one of those documents can serve as evidence showing the expectations that guided your financial choices. The second step is consultation. Retirement regulation intersects with financial organizing, tax policy, and estate organizing, which means the details can become complex quickly. Speaking with a qualified financial organizer, retirement specialist, or legal professional can help translate this Supreme Court determination into practical guidance for your specific situation. Professionals who operate in this field can assess whether any part of your retirement strategy depends heavily on state policies that could potentially modify in the future. They can also help you identify what records to maintain and how to organize your organizing so that your dependence on existing regulations is clearly documented. The third step is examination. For public workers in particular, this step can be especially significant. Reviewing pension documents, benefit formulas, and strategy descriptions can help clarify precisely what commitments were made when someone entered the system. If those terms were ever altered in a manner that significantly reduces expected benefits, the documentation showing what existed before the modification could become extremely relevant. None of these actions require complex legal knowledge. They simply establish an evident record of the expectations you depended on when making long-range financial choices. And in a legal environment where reliance interests may now carry constitutional influence, that type of documentation could prove far more valuable than many people understand. Let's take a closer examination at that first step, documentation, because it may turn out to be one of the most significant things individuals can accomplish in this new legal environment. The reason is straightforward. Dependence is much easier to establish when there is an evident record showing precisely what information people used when making their choices. Consider the types of details that typically influence retirement organizing. State tax regulations on pension income, whether Social Security benefits are taxed, the formulas used to determine public worker pensions, exemptions for retirement accounts. These policies are frequently published on government websites or explained in official documents provided to workers and retirees. Many people read this information when they are organizing their retirement, but they rarely think to save a copy. Under the structure described in this Supreme Court determination, maintaining those records could become extremely valuable if a state later modifies a regulation in a manner that impacts your retirement income. Having documentation showing what the regulation stated at the time you made your choice helps prove that you depended on that information in good faith. One of the easiest places to start is your state's Department of Revenue website. Nearly every state publishes detailed explanations about how different types of retirement income are taxed. These pages frequently outline whether pensions are taxed, whether there are exemptions for certain types of retirement benefits, and how Social Security income is handled. Simply saving a digital copy of those pages or printing them for your records establishes a time-stamped reference point. If the policy modifies later, you have a record showing precisely what guidance was available when you were making your strategies. The same approach applies to retirement strategy documents. If you participate in a pension system, maintain copies of the enrollment materials that explain the benefit formula and retirement eligibility regulations. If you are saving through a 401k, 403b, or similar account, maintaining periodic statements and strategy summaries can help show the structure you depended on when determining how much to save and when you expected to retire. Even official letters from pension administrators or retirement strategy providers can serve as useful documentation. Each one helps establish the expectations that guided your long-range financial organizing. Another significant part of documentation is simply maintaining an evident record of major choices you made, founded on those regulations. For example, if you relocate to a different state because of its retirement tax policies, maintaining records of that choice, such as real estate transactions, relocation documents, or financial organizing notes, may help prove that the relocation was influenced by those policies. When courts assess reliance interests, they frequently examine at the broader context of a person's choices. Showing that a regulation played a meaningful role in influencing those choices can strengthen the discussion that modifying the regulation later would cause real damage. Again, none of this requires complex legal strategy. It's simply about establishing an evident paper trail that shows the environment you depended on when constructing your retirement strategy. But while this ruling establishes significant safeguards, it's also significant to comprehend that it doesn't end the conversation. In many ways, it may actually mark the beginning of a new phase in how states design retirement-related policies. State governments depend heavily on their ability to adjust financial policies to manage budgets, respond to economic modifications, and address long-range pension obligations. When a Supreme Court determination introduces stronger safeguards for reliance interests, lawmakers and policy advisors naturally begin examining for ways to operate within those boundaries. That means we will likely see states experimenting with new strategies that attempt to adjust retirement policies without violating the principles the court described. Some of those strategies are already familiar in policy discussions. One approach is the use of protection clauses. Under this model, existing workers and retirees continue functioning under the original regulations, while new workers hired after a certain date fall under a different system. By separating the two groups, lawmakers attempt to modify future obligations without disrupting the expectations of people who already depended on the earlier structure. Another strategy involves gradual implementations. Instead of implementing a sudden modification that immediately impacts retirement income, a state might introduce adjustments slowly over many years. Lawmakers sometimes hope that spreading modifications over a longer timeline will reduce the financial damage experienced by individuals and make the policy more likely to survive legal examination. In other cases, states may simply pass assertive reforms and permit the courts to determine where the constitutional boundary lies. That approach effectively turns the issue into a legal test case where judges assess whether the modification respects or violates reliance interests. Because this ruling is relatively new, the precise limits of these safeguards will likely be defined through future cases as different policies are challenged in court. That means the legal environment surrounding retirement organizing could continue developing for years as judges interpret how far these safeguards extend. For individuals organizing their retirement, that uncertainty makes one thing increasingly evident. Staying informed about modifications in state policy is no longer just a matter of curiosity. It has become a significant part of safeguarding the financial strategies people have invested many years constructing. All of this leads to a significant realization that many people are only beginning to appreciate. Retirement organizing is no longer just about saving money, selecting investments, and determining when to stop working. It's also about staying aware of the regulations and policies that influence how that retirement income will actually be handled. For many years, many Americans assumed that once they comprehended the regulations, they could safely construct their strategies around them and move forward with confidence. But as pension systems, tax policies, and state budgets have developed, it has become evident that those regulations can sometimes modify. What this Supreme Court ruling accomplishes is acknowledge that reality while also placing meaningful limits on how far those modifications can go when people have already organized their lives around the original system. In effect, the court is acknowledging that retirement organizing isn't just a private financial exercise. It's a long-range partnership between individuals and the legal structure established by government policies. When people follow those regulations for many years, saving money, contributing to pension systems, or relocating founded on tax policies, the expectations established by those regulations deserve to be taken seriously. That's why awareness is becoming such a significant part of retirement protection. Knowing what your state legislature is considering, paying attention to proposed tax modifications, and comprehending how pension systems are developing can make an important difference over time. A single policy proposal discussed during a legislative session might seem like a minor technical adjustment, but depending on its details, it could influence retirement income for years or even many years. When individuals stay informed, they are far better positioned to respond early, ask questions, and comprehend how potential modifications might impact their strategies. In many cases, simply being aware of a proposal before it becomes regulation permits people to adjust their financial strategy or seek professional guidance before any modifications take effect. That awareness transforms retirement organizing from something static into something adaptable, permitting individuals to respond intelligently as policies develop. As we step back and examine at the bigger picture, this Supreme Court determination carries a message that goes beyond legal theory. For generations, people have handled retirement, organizing as a commitment, a dedication they make to themselves and to their families through years of saving, working, and preparing for the future. What the court has effectively stated is that when governments establish regulations that people depend on while making those strategies, those regulations carry their own type of commitment as well. They represent expectations that cannot be casually discarded after people have invested many years organizing their lives around them. The real question now is how states will respond to that new reality. Some will likely adjust their policies carefully to prevent conflict with the principles the court outlined. Others may test the limits of the ruling through new legislation that eventually operates its manner through the courts. Either manner, the ultimate strength of this determination will depend not only on the courts, but also on how informed citizens remain about the policies influencing their financial future. And that's why staying engaged with these issues matters so much. Information about retirement regulation and policy isn't just abstract legal news. It directly impacts the income people depend on later in life. When individuals comprehend how these regulations operate, they gain the ability to safeguard the strategies they've invested years constructing. So, if you found this analysis helpful, ensure you're subscribed so you don't miss future information as states begin responding to this ruling and new developments emerge. Sharing this information can also make a real difference. Many people are completely unaware that modifications in retirement policy could impact them. And simply passing along reliable information can help companions and families stay better prepared. And if you'd like to join the conversation, leave a comment sharing which state you reside in and what concerns you most about retirement organizing right now. Hearing those perspectives helps influence future discussions and maintains the focus on the issues that matter most. Because in the end, staying informed is one of the most significant resources anyone has when it comes to safeguarding their financial future.